Good evenings. Am I audible?
Yes, yeah, audible, yes, yes.
Yes.
Audible, not visible.
It is disabled, I think. Video on is not
Okay.
getting on. Now I think it will be.
So
Now,
now
yeah,
you
yeah,
are
now
able to
post,
do
yes, yes.
so. Now you
Yes.
are
Yes.
exposed.
Okay,
Good
so,
evening.
yeah, I think, shall we start?
Uh,
Only go to, yes, yes.
Good evening, sir. With your kind permission, can we start?
Yes, yes. Let's start. Yes, yes.
Good evening to everyone present here. I, Avneet Kaur, delegate of Sambhav Initiative and moderator of this event. On behalf of organizing committee, I extend a warm welcome to our esteemed dignitary, Dr. Hardik, Parikh sir, and all the participants in this first day of 15 days online national capacity building program on land, real estate, and property laws, jointly organized by Sambhav Initiative, which is working towards alternative dispute resolution, free legal aid, mental health, and creating legal literacy. Organized this program under the direction and guidance of Patron in Chief of Sambhav Initiative, Honorable Justice C.K. Thakkar sir, former Judge of Supreme Court of India, and Patron of Sambhav Initiative, Honorable uh, M.R. Shah sir, former Judge of Supreme Court of India, and Pro Bono India, which is working towards legal literacy and legal aid, where today's session is all about introduction to land and property law. Before we start the session, please adhere to some webinar etiquettes. I request all the attendees to keep their microphones muted during the session. If you have any questions, please use the chat box or raise your hands. Now, I would like to take the honor to introduce our esteemed dignitary, Dr. Hardik Parikh sir. Sir is currently serving as Assistant Professor of Law at Gujarat National Law University, Gandhinagar, Gujarat. Sir is the head of training division, faculty governor of the Legal Services Committee, coordinator for postgraduate diploma in intellectual property rights program, and faculty governor for pro bono club scheme under the aegis of Ministry of Law and Justice at the Gujarat National Law University. Sir has been awarded PhD in Law, Intellectual Property Rights by Gujarat University, Ahmedabad in October 2017. Sir has been a visiting faculty for law in more than 14 different institutions. Sir was practicing advocate in City Civil and Sessions Court, District Court, and Gujarat High Court from 2006 to 2011. Sir has also worked as Assistant Professor of Law in Institute of Law, Nema University from 2011 to 2013. Sir has conducted various training programs on different subjects of law for the institutions like EPFO, GSPL, GSPC, HPCL, GMDC, Directorate of Prosecution, Gujarat Police, GRC, etc. We are deeply honored to have you with us today, sir. Over to you, sir.
Yeah. Thank you so much for warm introduction. Thank you so much, Kalpesh sir and Thambao Initiative for inviting me and giving me the first slot with regard to the introductory aspect. I congratulate you to initiate this wonderful course of capacity building program where most of the topic relating to land law and relating various aspects pertaining to revenue legislations, real estate law is covered. I'll just share my screen. Let me know it is visible properly or not, and then we'll begin the discussion. Kalpesh sir, is it visible?
Yes, yes, yes.
Yes.
All right, all right. Okay, thank you so much. Okay, so welcome to all participants for the one of the most important subject we can say into domain of law. Today's task which has been given to me is with respect of introduction to land and property law. And when we talk about the land and property law, we can always say, I'll give a small statement, and that statement will be a beginning, or you can say a thought provoking thing for you all, that land and property law is one of the galaxy in the universe of law. If I say, and if I am able to reach out to all of you, we can say that land and property law is one of the galaxy in the universe of law. Now, why we have it is on just a comparison. Whenever we are talking about the legal domain, already there are multiple facets, multiple aspects of law, and legal aspects and legal regulations are available in almost every field, starting from criminal matters, civil matters, rent relating matters, consumer matters, construction, international aspect, national aspect, aviation, everywhere you will find out certain aspect. But out of this all, when we talk about the land and property law, we are comparing with the galaxy. Now, why we are comparing with the galaxy? Because a huge area of practice when you talk about the civil law is applicable here, and this is also has passed through one of the interesting discussion and or constitutional debates in our country. Whenever we talk about the land and property law in India, we have to keep in mind multiple aspects. You talk about the power, or you can say the legislative powers of the state as well as central government. You talk about the administrative aspects of the government. We talk about the different aspect in respect of the policy making powers which are available and distributed among the various stakeholders and among various important organs of the society. And therefore there are multiple facets which you are going to learn in this particular initiative. But when today's discussion is focusing, we are not able to, I'm not aware about the exit credentials of our participants, but as I am told, there is a mixed group of participants who are including certain students, certain faculty members, advocates also. And whenever we are practicing in the field of land and property law, there are multiple issues which we are trying to cover in first session today. Now, before we go, just have a look to the some of the figures which may be very much interesting for us to understand, because when you talk about the land law, when you talk about the property law in our country, what is the area? Because this is what a domain which is going to be covered. When we talk about India, 328.7 million hectares is a geographical area which is covered, and which is called as the seventh largest country in the world, having 2.4% of the total world land. Out of that, 71% land is covered by the forest area. That's a 7 lakh square kilometer. And 36.36% land, we call it as a urban area land. 42.4% total geographic area is a cultivable land. Now, you will be surprised that why this figure is in important for us. So whenever you talk about any law, it is always read or it is always understood with reference to the society, with reference to the stakeholders. A simple question may be asked, okay, whenever you talk about the land law, what are the beneficiaries? Who are the people who are going to be directly, indirectly affected, governed, controlled by the subjects? In order to understand, this is a particular figure which is talking about the urban area land, forest land, cultivable land. And this entire area is going to give you idea with respect of that. Now, more of that, as per the census of 211, 54.6% total workforce was engaged in agriculture and allied sector activity. Now, it goes without saying that when a large number of people who are working in a sector which is agricultural land, which is main important aspect of the land law, we can always understand that whenever any legislation or any policy is drafted, it is implemented, we always consider the interest of the people who are going to lose the land because of multiple reasons, and it may be for development. Obviously, there's a 13.7% share, and some of the various important particular crop is available here. Now, when we talk about the property law, land law, this is the classification which you can always understand and keep in mind. Already, law is becoming a super specialist subject nowadays. There are regulations at every level. You study the law in a various aspect. Now, when you broadly classify, we consider generally the land which is available on surface. Already, we see on earth, the majority of portion is covered by the ocean, right? And then whatever land is available on surface, and when you talk about India, generally we talk about the forest land and non-forest land. I have given this classification because generally we have seen that complete control and restrictions are available with respect of the area of land which is actually covered by the forest area. And therefore we have Forest Conservation Act, Indian Forest Act, and there are multiple laws which are recently enacted in form of the Forest Right Act, etc. So generally activities development is always governed. Obviously legislations are available which is talking about the controlling forest, which is talking about taking minor and major forest product out of the land, licensing to do activity into the forest, and many more. Now, when you talk about the non-forest land, again we are bifurcating the land, that land which is available on surface, land which is subsoil, and land which is covered by the water bodies. Now, why this three bifurcation? Land which is on surface, obviously the usable, cultivable land, which is always part and parcel of the state rights whenever the policies are made or govern about that. But when we talk about the subsoil, it is also coming under the legal regime, that how the subsoil and minerals and various aspect or various deposits or various things will be taken out from the land. and who will be governing these particular components, and how the limitations and different kind of the permissions are granted. So subsoil is also covered. When you talk about land covered by water bodies, it is also part and parcel of the rights, which is included in form of the river, in form of the lake, in form of the pond. And whenever it is not covered with this water, how the land will be utilized. For that, the local legislations and local regulations are prevailing. Now, when you talk about the land on surface, again two bifurcation, agricultural land and non-agricultural land. Now, when we talk about agricultural land, there are multiple legislations in form of the state legislation for maintenance and preservation of the agriculture. Now, the legislation which are there when Indian Constitution was adopted and when we implemented the provisions, we always kept the interest of the agriculturist that whatever the rights over the land, now whether it is a zamindari system, whether it is a Ryotwari system, whether it is a Mahalwadi system, once upon a time prevailing systems where agricultural was taken into consideration not directly by the owners, but rather than it is kind of shared, or you can say the crop sharers, or land is given to someone by virtue of certain mechanical mechanism arrangement, and then the tenants, or you can say the peasants who are going to cultivate the land, will pay the revenue and will be subject to multiple important government or government regulation will come into picture. So for that, whenever it was observed that there is a Zamin, there is an intermediary which has been created, there is an exploitation of the people who are cultivating is created, then the multiple legislations have been enacted in form of the protection of tenancy, in form of the prohibition on bifurcation, division of the land, in form of the governing regulation, revenue of the land, etc. So there are regulations which are available, which you are going to understand in case you are talking about agricultural land. Also, important aspect in form of the conversion of the agricultural land into non-agricultural purposes. It's a nationwide discussion which is going on. We have seen.
Hardik, sorry for interruption.
Yes,
Mohammed Dadni, please remove this annotation.
sir. In case you are a,
I have stopped again,
in case you are a particular, yes, I think I can remove. You
yeah,
can
over to you.
deactivate annotation, sir, in case if possible.
Yes, sure. I'll just.
Yes, yes. All right. I hope I am audible and now can go ahead.
Yes. Over to you.
All right, all right. Thank you so much. Okay, so that was the important point. So whenever we talk about the area of practice, the conversion, the nationwide discussion is going on. That slowly, gradually, the agricultural area are degrading, and also we have seen that it happens with the almost all the metro cities and capital of our different states. Wherever we have seen that most of the land which is covered by agriculture in the outskirts of the cities are because of the expansion of the cities, it is getting covered. So there are multiple regulations, powers have been given to revenue authorities, state authorities to give permission that on what basis this will be converted. Now, when the land is converted from agricultural to non-agricultural, then also plethora of legislations come into picture about the zoning regulation, that in what areas residential permissions are granted, on what areas commercial permissions are granted, on what areas industrial permission will be granted. Also, apart from this agricultural to non-agricultural, ground level water authorities are established in many states, and they are also taking care about the development permissions whenever they are granted to any authority or any person or any government or joint venture which has been established with the government, that to what level you are going to exploit the ground level water also. So when we talk about the introduction to the land law, generally there is no ultimately, there are two kind of things which are coming into picture. One is the land law, and second thing on a lighter side, people say law of the land. So we say the law of land will be the constitution of India, which is governing multiple aspects. But on that particular piece of land or in area of the state or its government or central government, whatever different regulations are coming, these regulations are in a different formats, because every activity which is happening over the land is purely governed, classified and regulated with certain piece of legislation which is available on the broad classification on the screen. Okay, so therefore it is becoming a very rich area of the practice. As we are unable to cover all the legislation together, we are going to get an introduction to some of the important aspect, but still you can always note down that these regulations are available as per the important requirement, case to case basis, whenever we are going to get it. Now, when we talk about the various aspects of land law, as I told you that it can have multiple visions, I have identified almost 10 different aspects of the land law which you can always keep in mind. First is a constitutional aspect. Land law is always studied with respect of the constitutional aspect. Little bit we are going to discuss today, that how the Constitution of India was giving the provisions with respect of the right to property, more particularly talking about land, and later on what changes have been brought, what constitutional amendment were brought, and what is the current situation right now. So there is an entire a category of education where the research as well as multiple aspect is possible, where you talk about the constitutional aspect. There is a property aspect of land law. As I told you that property, there's a bifurcation of the property. Generally, in case there are participants who are not from law background, I'll just briefly introduce you that whenever you talk about the property, a very simple definition of the property is given. Property is an interest recognized and protect any kind of interest which is in form of the bundle of rights for you. So property in very simple sense we say bundle of exclusive rights. Now there are multiple rights available to property. Now when you talk about the right, it is considered as an interest recognized and protected by law. So law has created one right, and this kind of multiple rights, right to use, right to dispose, right to lease, right to use in a whatever way you want, right to have different kind of division, right to give in succession. These all rights are coming with the property. Now, broadly, there are two categories of the property also. One is tangible property, one is intangible property. When you talk about the property, what is tangible property, which is again bifurcated into movable and immovable. So legislations are available to regulate all the aspects. So one classification, as I told you, tangible. Another classification is intangible. Tangible again bifurcated in two ways: movable property, immovable property. Now, when you talk about Indian Contract Act, Sale of Goods Act, these are the legislation which are talking about the movable property. So whenever movable goods are into transaction, when it is transferred from a party to the other, at what point of time the sale will become absolute, what right will pass, that legislation is taking care about that. That's a property law aspect. When you talk about immovable property, again we are governed by multiple legislation. Some of the legislation we are discussing, the category which I gave to you right now, that generally we talk about the Indian Contract Act and Transfer of Property Act. So when Transfer of Property Act come into picture, it is taking care about multiple ways how property may be transferred and what are the regulations and what are the legal requirement. Please keep in mind that whenever you talk about the immovable property or property law in our country, when you talk about the immovable property, it is very difficult to hand over the possession. It is not like a movable goods, and therefore there are certain norms and certain legislations in form of the provisions for valid deed or documentation whenever the rights are transferred from a person to the other. There is a provision for registration before any proper authority, and therefore the government is coming out with the registration department, that who are coming with the all record of right or revenue records, where systematical chain is maintained from the beginning, that originally who was owning this piece of property, how it was divided, how it was sold, how it was bifurcated further, how was it was amalgamated, and so and whatnot. So this is aspect about the tangible aspect of property when you bifurcate property into movable, immovable. And when you talk about intangible property, again we have a separate facet of the property law in form of the intellectual property law. When you talk about the patents, trademarks, copyright, which are ultimately rights over your creation, rights over your originality, but as it is not part of the normal property law and subject matter of this program, we are not touching them. But there is also property lawyers who are properly practicing into intellectual property rights also. So this is broad bifurcation of the property, and whenever you understand this bifurcation, you always get introduction that yes, land is also becoming very important part of the immovable property. Then there's a taxation law aspect of the land law. How it is possible that land is always subject matter of the taxation, because from the time of British government, I will discuss some of the historical incident in front with you, that land has become an important area for revenue, a source of revenue earning from state. Once upon a time, the emperors and kings ruling. In later on, if it has been taken care by the British government, then for British. And after independence of India, when Indian government, central government, state government have taken charge over the land, we say that all land is part of the taxation, and there is always chance of the litigation. So taxation, which is called revenue, what amount of land revenue equal for all kind of land or different land. There are certain legislations by zone. So residential property and taxation, commercial property, property which is already transferred from commercial to industrial, what are the different revenue, how revenue will be recovered, what is the rate of revenue calculation, what if revenue has not been paid, whether any exception will be given to you or not. These all are regulated, and for that there's a separate facet or aspect which you are learning in form of the taxation law. Then there's a corporate law aspect of the land law. I am highlighting the important areas that how property laws can be studied and what are the areas of practice you can see. Now, what is corporate aspect of land law? Recently, you might have studied in 2021 when government introduced three new farm laws, right? One of the aspect was relating to contract and corporate farming. Now, there is a very popular word right now available in form of the farming activity. The land and the way it has been used, there are multiple questions concern also about the agricultural productivity. And therefore, considering the foreign experiences, in India also many interesting examples are there where you talk about the contract farming, when you talk about the corporate farming. So directly entering into contract with the for the usage of the land, directly taking control of the land by the corporate entities, and obviously there are legislation in our country when which you will get exposed to in this course, that there is always restriction on usage of the land. If there is agricultural land, the land will be used primarily for agricultural purpose. It is not a developed land. It is land which may be irrigated or non-irrigated land, and only farmers can have access to the land. In case the land is required to be owned and controlled by the non-farmer, you need to follow the procedure established by the state government, because generally it is part and parcel of the state government subject. And therefore, there's a direct clash or there is a different kind of the conflict of rights, that what if any corporate entity want to do the business, want to have the usage of the land, how this entire model will come. So there are interesting issue. You might have heard about one of the issue of the PepsiCo in Gujarat only about the potato farming. So that's the corporate flavor of the land law, where entire legislations are studied with respect of getting rights of the corporate over land. Then there is an environmental aspect of the land law, how environmental aspects come into picture, the usage of the land, the usage of the subsoil, soil, ground level water, and how environmental pollution is getting generated, and what are the usage, what are the environmental norms over there. And therefore, here, whenever you talk about land law with the corporate environmental law flavor, you always keep in mind the regulations which have been created for the eco zones. You might have studied that, you might have heard that many state government have defined certain land in under the eco zones. So whenever the eco zones regulations are passed, your activities are restricted. It may be in form of the construction activities, agricultural activities, mining activities. It is always kept in consider proper by after considering the environmental regulation only, including environmental pollution, which may be air, which may be water, which may be ground level pollution. So there's a separate aspect when you are also practice and when you are also going to understand the land law with the environmental aspect. As I told you, intellectual property law aspect, it is also available in land law when you talk about the special plant variety protections and right over the land. So there are certain developed practice and techniques in form of the tissue engineering where the farmers or the cultivators, breeders are also entitled for certain kind of IP protection, because they have identified the area of land and they have included or initiated or introduced certain wonderful tactics and areas where you can always grow good amount of crop. There are certain hybrid crops, there are certain biotechnology used. So whenever you are using the land for this kind of purposes, IPR aspect is coming into picture. For that, we have separate legislations available. Then civil and criminal procedure, those who are practicing as advocate, and there are multiple matters relating to land disputes. Civil and criminal matters are available. You will surprised to note that highest number of disputes in the civil law are relating to property, and this property are necessarily relating to succession, relating to partition, relating to conversion, relating to multiple zones, and then also the use of the land in a way which is against the interest or against the central government or state government notification. And then multiple actions have been taken by state government, including taking the possession of the land, charging exorbitant amount of land revenue, or giving you certain kind of the directions to restore the land for to the original situation. This all is governed by the civil and criminal procedure. Also, the examples of the land law, which I told you, that like a provision for fragmentation and consolidation of the holding, provision for land revenue code, provision for tenancy and agricultural lands act, also inherently providing the provisions for appeal, review, revision whenever actions or orders of the government authorities are subject to challenge. And therefore, the civil and criminal procedures are also available in the land law. So the advocates are also able to get the special area of practice under this aspect. There is an international law flavor of the land law also. Those who are learning first time, you will surprised to note that how land law is connected with the international aspect. I'll give a simple example. You might have all studied about the Special Economic Zones, right? The Special Economic Zone Act, which is in the year 2005, which has been introduced, and it is implemented from the 2006, and now it is also working, which is considering a land which is belonging to any state government as a land which is under the central government notification, notified as a special economic zone, and this particular land is purely governed as a foreign island in case it is established under the special economic zone and given to any foreign party for manufacturing or for a specific purpose. So it can be multiple sector, multi-sector, particular special economic zone. It can be individual or single or any kind of simple single action special economic zone. And here the international aspects come into picture, because when the land is utilized, generally land belong to any particular state government, and central government has come out with a notification. It has been given into the power and authority control of any particular entity, which may be a joint venture, which may be a foreign entity which has established itself as a developer under the Special Economic Zone Act, which has relaxed laws. So there are environmental laws, labor laws, multiple state legislations, as well as the different licensing provisions have been relaxed. There's an international aspect of the land law also covered when you talk about the land matters. There is the economic aspect and scientific aspect. Economic aspect, we always say land is one of the most important area of economic development, because the limited area of the land and whatever best use can be done by virtue of the various policies enacted by the state government, the development will be there. So what should be the best model of economic development of the land? That is becoming the important aspect. For that also separate research can be there. And finally, scientific aspect of the land law. It is also for scientists, and it is also for important people who are going to do the scientific environment. The calculation, measurement, as well as the proper provisions with respect of the soil testing, checking the quality, different kind of the fertility of the land, and advising the people of the state, advising the farmers that what will be the best crop for their particular development. This is also one of the important issue relating to land matters. So these are the important aspects of the land law which you can cover. So those people who are willing to understand the land matters, this all area are specific area of research, specific area of application, where the state central legislations are available, and you are able to do the wonderful thing about that. So what are the major components of the property rights and the land law? Before we go to the some of the historical development and the nature of property rights in our country, there are important aspects. First and foremost is a constitutional aspect. There are a lot of things to understand. Comparing, when you are comparing the Indian provisions or Indian land law with a foreign country, always the situation comes into picture that what is the nature of the right over the land, whether we have absolute right over the land in form of the fundamental right, or it is only right in form of the human right, or it is a right in form of the legal rights. So whenever you talk about rights, there are four broad categories. First of all, you talk about the human rights, which are by virtue of the UDHR, and broad rights have been given. Second category comes in form of the legal rights, which are by virtue of any legislation enacted. You talk about copyright law, you talk about the patent law, which are because of any specific legislation. Then third category comes in form of the constitutional rights, the rights which has been granted to you by virtue of the Constitution of India. And fourth category, which is coming in form of the fundamental rights. So fundamental rights, constitutional rights, statutory rights or legal rights or human rights. What is actually nature of the land law? Because whenever we see the petitions in High Court or in Supreme Court, you will find out that multiple petitions are filed, multiple requirement have been created by the people, and challenges have been happening with respect of the regulations, rules, notification, by claiming that because of this notification, because of this regulation, our rights are getting violated. So this debate is governed by the Constitution of India. We are trying to touch some of the aspect right now today in the session, which will explain you the fundamental aspect of the property rights. So this is first component. Whenever you do a legal practice or you want to understand the land law, you have to start from the stretch from the constitutional aspect, that what actually the Indian Constitution has provided with respect of the land law. Second components are in form of the land acquisition legislation. Whenever we talk about the important aspect about the land matters, these are the important aspects which are governed. Originally, we can say that in India, from the year 1824, the land acquisition legislations are available. 1824 is a time where the law was prevailing from the time of British era, when in Kolkata, in Madras and Bombay presidency, for making railway bridges, for making roads, for making canal, British government started acquiring the land. And later on, slowly, gradually, that development happened in form of the 1894 Act. But in 2013, this law has been repealed. And now we have the law in 2013. The full name of the law is Right to Fair Compensation, Transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013. So this is also legislation which is there to be understand, because right now whenever the land is acquired for multiple projects including port development, canals, railways, highways, multiple special economic zones or any other public utility services, are comparing to the old provisions of 1894 Act, we have higher provisions and higher rights for the people. So now giving fair transparency, compensation is becoming mandatory. Transparency has become mandatory. Providing rehabilitation resettlement to the displaced people has become mandatory. Not only that, but giving a opportunity to the people before land is actually acquired in form of coming out with the social impact assessment is also mandatory. So these all things have been governed or has been available. So those people who are understanding about land acquisition are going to have an idea with respect of the right which are available in form of the 2013 legislation. In 2014 and 15, I have written ordinance because there is again interesting journey. Also, time is not permit, so this point you can cover. But it is interesting that when in 2013 Act came into existence, it was implemented from there 2014. At the time, the separate government was available. There's a UPA government was there in the central level. The moment new act came in 2014, and within 4 months, in May 2014, the government got changed, and then NDA government came into power. Now, when the NDA government came into power, it was a big obligation and big hurdle, we can say into inverted comma. That is, the two legislations were enacted by the previous government. One was the Food Security Act 2013, mandatorily giving food security as a right to all citizens of the nation. And number two, this legislation which is making it mandatory and obligatory to follow the higher norms to acquire the land comparing to the old law. And therefore, the first action taken by government in 2014 was that introducing the ordinance in 2014, changing some of the provisions of the law. And these changes were more particularly in with respect of the eliminating social impact assessment. And that is for the projects which are in form of the affordable housing, industrial corridor, or any kind of project which is for national importance, social, or any kind of the army, navy, air force relating projects. And therefore, this ordinance introduced once in 2014. Again, it was introduced into the parliament in form of the bill. Unfortunately, at the time, there was a big outrage, there was a big opposition by the political parties. This legislation was not identified, it was withdrawn by the government. But obviously, it is always understandable that in future also, when government is willing that some of the provisions are required to be changed, it is also important to study this ordinance. So whenever you study land acquisition act, you can always cover the ordinance 2014 and 15, that what was the effort of the government to change this legislation. Then there are legislation in form of the special economic zone, which I told you that the law which is governing the area, considering them as a special economic zone for specific activity. Generally, they are for the manufacturing or any kind of service industry. And then there's a plethora of legislation in form of the land reform. What are the legislation? Tenancy and Agricultural Lands Act, the Prevention of Fragmentation and Consolidation of the Holdings Act, land ceiling legislation for urban land, for rural land, town planning and urban development legislation. These all categories are part and parcel of the land reform legislation. Now, why we use the word land reform legislation? Because generally after independence of India, we came out with the legislation in this different nature. It is mandatory for every title clearance advocate or any advocate or any academician who are going to understand the different aspect, because the state legislations are available, and it is always presumed that the pre-independent era was considered to be the exploitative era. The people who are cultivating land did not have any right. The owners were exploiting them. Exorbitant amount of land revenue was recovered. There was an unequitable parallel or unequitable pattern of land holding. And therefore, considering the requirement, government came out with the legislation. So whenever you do the work at the grassroots level, this all legislation come into picture. And then for whenever you get introduction to the land law, property law, we always keep in mind that state government has power over the land, which is agricultural land in nature, and therefore they are empowered to come out with the legislation in nature of this few example which has been given in front of your screen. So Tenancy and Agricultural Land Act are providing the provisions that how tenants' rights are protected, when the land can be vacated by the owner, when the land cannot be vacated, what are the obligations to pay the revenue, how tenancy can be terminated. These all things are covered by the Tenancy in Agricultural Land. Almost in every state these legislations are available and they are proactively followed also. Also, the permissions to convert the land from agriculture to non-agriculture is also coming under the preview of the Tenancy in Agricultural Land Act. In Gujarat, it was Bombay Tenancy in Agricultural Land Act. Later on, it became the Gujarat Tenancy in Agricultural Land Act. Then there's a Prevention of Fragmentation and Consolidation of the Holdings Act, the act which is making a provision or providing that mandatorily you are not supposed to divide the land by virtue of the succession also. Whenever you talk about the property law, let me tell you, there is one of the interesting aspect that property is always subject matter of division. It can be given in succession also. So whenever you are owner of any property, you can always pass it to your succession. So suppose a father has a 4 sons and 2 daughters. In case father is dying without any will, the property will be divided equally among 7 people. Wife, there is a mother, 4 sons and 2 daughters. And therefore, this has happened in many parts of the country, that after the death of the father, property is divided, and everyone who is becoming owner of the small piece of property is becoming ineffective. They are unable to get it. They are unable to get any kind of uh, provision or any kind of benefit, because it is always understood in light of the productivity, the larger area of the land and the resources which are used by the farmer and income which will be generated would always be higher than the area of the land which is smaller, and then it is not possible for the farmers to use it. What can be done? And therefore government came out with the legislation in form of the Prohibition or Prevention on Fragmentation. So the law is prohibiting that even though you are dividing the any other property, you cannot divide the land less than the fragment. You have to do voluntarily joint cultivation only. And this is how restriction is available on the right of disposal of the property. And when land is already divided, but then based on the government scientific survey, if government is coming out that a minimum area of the land should be this much, then therefore the small area of the land are consolidated by virtue of entering into record of right. For that, you will understand separately the revenue procedure, and therefore 5 different holders are made a mandatory provisions, and their land is getting accumulated and joint cultivation is done. That's the procedure, and that's how the land reform is also taken place into country. So whenever the title search or property matter search or the selling of property is happening, this all entries and this all you can say the mutation entries are always checked. And if there is a restriction under this state legislation over any land, the government will always deny that this land cannot be sold unless and until you are getting it clarified, you are getting it permitted through the various authorities. Then there's a land ceiling legislation. We might have heard about the urban land ceiling act, which is again putting a cap that how much land in urban area maximum a person can hold. So this land is always restricting the holding of the land. Unfortunately, this urban ceiling land legislation was held to be not valid, and obviously in urban areas the cap was not acceptable, therefore ultimately it was repealed. But today also Agricultural Land Ceiling Act is available. So in many states the government has put a cap that how much a farmer can own maximum agricultural land. Therefore the excess amount of land either will be taken care by the government or it can be held by the family members only, or the extended family members. Means you should own only that much land which you are able to cultivate, and you should not do a activity when you are owning a huge amount of land and keeping certain people under your supervision and you become zamindar later point of time. So this is what ceiling legislation. And finally the broad practice area is in form of the Town Planning and Urban Development Act, one of the most important legislation. You might have heard about the many towns and cities which have been very well planned in our country considering the zones. Now there is an interesting question that suppose I am owning a piece of land, I have some amount of money I want to invest, I'll go 100 200 kilometer away from my city, invest in some area, and then that area of the land will belong to me. Now, technically, should I not do anything on the land? I will create a farmhouse. I will construct a farmhouse. I will create a borewell. I will do this all activity. Technically, as a right holder, I can do that. But ultimately, the legislations are there which are governing that development of the land will always be part and parcel of the state government's prerogative. So you cannot come out with any construction any point of time. There are certain permissions required from the town planning authority, and therefore there is a very popular word in form of the TP schemes, right? We call it town planning schemes. So under the town planning and urban development legislations, the town planning and urban development authorities are constituted. The authorities take care about the town planning scheme. Every town planning scheme is dividing the land into residential zone, agricultural zone, the commercial zones as well as industrial zone, and your land is falling under that zone. Only that activities are permitted, so that entire residential area can be free from some other non-residential relating aspect. So that thing is also governed, and for that the detailed legislations are available in every state, which is form of the town planning and urban development authority. And finally, when you talk about the land revenue legislation, land revenue code and land revenue rules of every state is applicable, because land revenue ultimately talking about the method of collection of land revenue, what amount of land revenue is recovered. An important point of land revenue code is in form of the revenue records or records of right. You all have, in case you have happened to study or read the sale deed, there are some quantitative paras which are mentioned into the revenue history of the property of land which is transferred, or property of any building which is transferred. So this is primarily governing that what was the original owner of the, who was the original owner, how land has systematically passed from one chain to the other, and the person who is selling you land have proper title over the land or not, and therefore record of right, and then multiple provisions are available. So this is what revenue registrations are also important. And finally, there are certain important laws which are also governed, which is in form of the Registration Act, which is talking about mandatory registration of the property, which is under the Transfer of Property Act. So sale, mortgage, different kind of the lease agreements, also the assignment, this all is mandatory required to be registered. For that the special authorities are appointed. The Stamp Act is also becoming mandatory whenever the transactions are happening. So there is a proper application of the stamp duty. And finally, Real Estate Regulation and Development Act, which is there, which is main part of the discussion, where the different disputes and conflict between the buyers as well as the developers as well as the sellers, how to avoid the transaction, how to create certain economic system, monetary system, that funds received from one buyer would not be misused for any other purpose. For that, regulation is available. So as I told you, that land law is considered to be the galaxy, and galaxy is available in form of the multiple aspect. Therefore the few introductory aspect has been presented here. Few important provisions are also there, like there is a scheduled caste and scheduled tribe prohibition of transfer of certain lands and atrocities. There's a SC/ST, there is a Forest Dwellers Act, which is also in form of, in short, it is known as a Forest Right Act. The right which is created in form of the forest tribal, I told you originally that there's a forest land. The forest tribes are residing over the land, but because of the law like Forest Act, Forest Conservation Act, the tribal communities were considered to be the trespasser. And therefore, in order to grant them right, the special law has been passed. In 2012, rules have been made. So whenever the land rights are studied, when you talk about the forest area, this law become important. There's a Forest Land and Forest Conservation Act also, and Plant Variety Act also. So few provisions are available with respect of the uh, overview of the land rights. Whenever you talk about the land, it is not like a simple legislation, but multiple aspects are touched in form of the revenue, in form of the records of right, in form of the agriculture, and so on. So these are the broad important aspect of that. Now we are going with the important aspect that whenever you talk about the land law, the who are the beneficiaries? All practicing advocates, whenever nowadays legal advisors are in public sector undertaking, banks, financial institution, when they are specifically appointed to see the land matters, because whenever any mortgage or any kind of documentation are done, you always are entitled to check whether the person who is entering into transaction have proper rights over the land or not. Solicitors are also coming into the form, where they are giving you certain advices with respect of that. Although in India we don't give any degree like solicitor, but originally it was available. Civil services, when special officers, land acquisition officers are appointed. The knowledge with respect to all this aspect is considered to be the important and must. Then, as I told you, that new law on for land acquisition has created a one barrier that before land will be acquired, you have to conduct a social impact assessment. Now, social impact assessment is very big task, which will take almost 12 months. You have to ask each and every landholder, the person who is owning the land, what they are losing, only whether they are losing land or they are also losing their livelihood. Are they going to get any kind of alternative? This all study is prepared in form of the social impact assessment report. So nowadays, the special area is available for practice consultant. They can also get aware about that. Contract and corporate farming activities, as I told you, that nowadays the new legislation which was originally introduced by the government in 2021 but later on withdrawn is creating on one new area of practice, that what contract and corporate farming activities are possible. And when a corporate entity is entering into contract with a farmer, and suppose if the crop is not as per their expectation, or if the farmer is not selling the crop to them as per the contract, what actions can be taken? Whether you will go into normal courts in order to enforce the normal contract, or there is a special authority which is required to be considered or which are required to be created. So this aspect is also available for people who are practicing in this area, can also get it. Social activists for forest rights, farmers' rights are also important aspect. And finally, when we talk about judges, lawmakers, policymakers, everyone who is willing to make any career into any of the field, knowledge about land rights, property rights are becoming important and indispensable for all the same. So this was the broad overview which was presented in front of you. Now, a little bit time which we have, we are going to share on the very basic aspect with the question which I asked you, that what is the nature of the land rights in our country and how these various land rights came into existence. Do we have any right in form of the fundamental right, or it is available in form of the constitutional right, or it is something different? So when we say from the primitive age, land has become an important source, and most of the disputes of the world also, you will find out they are connected with the land. Whether you talk about the World War One, World War Two, many more aspects, most of the time you will find out the land has been available because land has multiple significance in form of the environmental, economical, societal, spirituality. Many people are coming out with the jurisprudence. Cutting short the discussion, we are not going into detail of this, but there is a significant resource also. And therefore, there's always a question asked that what's the best utilization of the land resource? And whenever a country is possessing whatever is country is possessing in form of the land matters, how they have to go together. And therefore, the question is always asked with respect of the controlling land resources. More quantity of the land is considered to be the more wealth for the people as well as for the government also. And whenever international environment got changed, the maniest concept came into picture with respect of the land matter also. So independence of the country, when it was happened, then land matter and land right become very prominent. Recognition of the government in form of the central government, state government also came, and ultimately recognition of the right by virtue of the various aspects. So these three broad categories came into picture where it was available. Kalpesh sir, I will put my laptop on charging. Just give me 1 minute.
Okay, sure, sure.
Yes, sir. Am I audible now? Sorry. The battery got drained and yeah, am I
Yes, yes,
audible now?
over to you. Yes.
All right. Okay. So quickly, as I told you that introduction to the land law we are doing, and we have seen that what are the broad categories of the legislation which are coming into picture. Now there are certain specific query. I think we can take it at the end. I will quickly bring your attention to some of the interesting development, because whenever you talk about the land law, one question we always ask: what should be the best model of land ownership? Now, what is meaning of this? Whether it is always good that state will be the first owner of the land and all the people should be secondary owner, and therefore all activities will be purely governed as per the instructions of the state only, or there will be a sharing model where the people are also getting rights over the land and they are getting complete freedom to choose the way how they want to dispose and how they want to govern the land. Now this question is becoming evergreen because there is no common answer to that, rather than the first important concept is available, that there is a concept of eminent domain. And whenever we talk about the eminent domain, the principle is available with respect of the state. So sovereign can do anything if the act of sovereign is involving public interest. And this is what a broadly connected concept with the land development in our country. Now, I will bring your attention whenever India got independent, there are certain important aspects which are available. And at the time of independence, this was the particular structure. Whenever you see that, whenever you talk about the land right today also in a many states, there are very ancient legislation. Now this map is very interesting to observe, that it is showing you the situation, that what was the situation at the time of independence with respect of the land ownership. So the pink color is reflecting princely states which were owning the land, having complete control over the land. And then yellow color is considered as a British India, which is available. Now, whenever you talk about the state legislations, the provisions with respect of this land is very important, and there are a lot of influence available from that also. These are some of the figures which you can see, that area which was held by the state government at the time, princely state. And then it is also shown that what amount of area, square kilometer, was also owned by them. Total areas of the princely state, 28% population were under control. And also it has been said that more than 75,000 soldiers were held by the princely state over the army. Now how this figure is available? Because when we brought the concept of social security, when India was planning to come out with the Indian constitution, we primarily thought that let us have a social security concept. For that, we came out with the directive principle of the state policy also, and we came out with the multiple legislation which are in form of the labor protection. But let me tell you, land was also considered to be the one of the important component, that in case we are not going to reform the way land has been owned and managed, the social security won't be possible. And therefore, this concept was becoming very prominent. And then we brought this particular aspect of the constitutional causeway. And therefore, in Constitution of India, we got the provision that how the land rights will be divided between the central government and state government, and then how judiciary's role will come into picture with respect of that. And at that time, three articles were very important: Article 19(1)(f), Article 19(5), and Article 31. A small discussion, but it is going to help us that what is the right of the state government, central government, and how different kind of the actions are taken. So Article 19(1)(f) was granting a fundamental right of property to all the citizens. Unfortunately, today this right is not fundamental right. We all have studied Article 19(1), where 7 fundamental rights were available. 6th fundamental right, second last, was all citizens shall have right to acquire, hold, and dispose of the property. So right to property was considered to be the fundamental right when Indian Constitution was enacted. At the same time, this fundamental right was part and parcel of the reasonable restriction that was under Article 19(5), that whenever any general public or any protection of the scheduled tribe is considered, the government can control this right to property. So when fundamental right of available in form of the right to property, it was subject to reasonable restriction. But we had Article 31 also, which was providing for compulsory acquisition of the property. We are not going into detail of this whole article, although in the presentation I have added. But then there is a parallel situation, that there is a property as a fundamental right. At the same time, government is also empowered to compulsory acquire the property for multiple reasons. And then there are multiple areas which has been mentioned, various clauses, that in what aspect available. Now, most interesting thing is about this. Whenever we talk about Indian Constitution, have a look to this chart, that in Schedule 7, Article 246, These are the list and entries which are talking about the primarily the land matter. So when you talk about union list number 1, taxes on capital value of assets, estate duty, these are the rights which are talking about the union rights. When you talk about the state, this many entries are available: land rights, tenures, rents, loans, improvements, revenue, assessment of revenue, collection of land revenue, taxes on agricultural income, taxes on land building. This all is part and parcel of the state right. For the people or for the participants who are not aware about this, whenever the subject is in union list, only central government can make a law on that. Whenever there is a subject is in state list, only state government can make a law on that. But when the subject is in part and parcel of the concurrent list, central government and state government both have right to make a law. If the central government is making the law, state governments are getting option. They are able to adopt the law, and then they can make certain kind of regulations and rules for that. Now, entry 17A and entry 42 are talking about the property. Now, you see, generally, when we talk about the land rights, almost all rights are available to state government. And therefore, this is called a federalism structure, that all the land which is belonging to particular state is entitled to come out with the legislation. And therefore, whenever you talk about the property law and more particularly land laws, you are primarily going to study the specific state legislation, and that's how it is going to be governed together. Apart from that, there were certain entries also: entry 33, entry 36, entry 42, which talks about acquisition of the property, some of the provisions which are available for acquisition for the property which is part of the union, and so on. Now, when you read both the article, they were taking care about the two contradictory things. Number 1, right to property is a fundamental right, and number 2, protecting the legislation which are acquiring the land in a public interest. These are the two parallel things available. But then some of the important aspect happen in case of the Bihar Land Reform Act. Now there is a drastic change. Now onwards, few minutes, you will be able to see that why the right to property was once upon a time fundamental right is not a fundamental right now. And now what are the important challenges available? So when we were planning to have, I told you, the land reform legislation, government came out with the Bihar Land Reform Act. Now that land reform act was in form of the abolition of zamindari system. At that time, Sri Maharaja Dhiraj Sir Sri Kameshwar Singh, very popular renowned name, Maharaja of Darbhanga, challenged this particular law because this law was held to be violation of the fundamental right, more particularly Article 19 and Article 14, because government by virtue of enactment of this law abolished all zamindars. So whenever zamindars, I have put the content, but because the time is less, I am telling you the base broad story of this, and then we'll conclude the discussion with some of the interesting examples and the question which you have put on your chat box, that if you are zamindar, your rights will be automatically suspended, and in case you are big zamindar, then you will be able to get a 3 times compensation comparing to the 20 times compensation in case of the poor man. This question was challenged, that how come in independent India, where any unequal treatment can be possible or can be available for the people who are owning the right. And therefore, the Patna High Court held that this particular law is unconstitutional, and therefore it was considered to be the unconstitutional because it was a discrimination. Supreme Court also upheld the constitutionality. Yes, this kind of law cannot be possible. Now, this is what we are talking about, the land rights, which is ultimately not of individual, but of the princely state owner. Once upon a time, when the entire land was owned by the princely state, and then the Maharaja at that time is challenging this particular thing. At the same time, there were two other states also came out with the law, because in 1950 almost all the state governments started making changes for the land law, the Madhya Pradesh and Uttar Pradesh. But this law were held to be valid. Now, whenever the Supreme Court held that Bihar Land Reform Act, which is abolishing zamindari and taking land right from the people, is unconstitutional, now the ball went to the court of the parliament, and parliament had to react. And parliament reacted because the parliament came out with the first constitutional amendment, and therefore we got the Article 31A and 31B. Now, what is 31A and 31B? 31A and 31B is coming out with the provision that any law, when it is enacted by the parliament and when it is placed into Schedule 9, it shall not be challenged in court of law. So whenever we talk about the land rights and how the rights got changed, these are the historical incidents and development and examples, that the one law was made by the government, held to be unconstitutional by the Supreme Court, and in order to overcome or in order to reverse the judgment of the Supreme Court, Parliament enacted this particular law by virtue of the constitutional amendment. So whenever any law is made into Schedule 9, you cannot challenge the constitutionality of that. And this become a wonderful thing. Now government can make laws in order to regulate zamindari, in order to abolish zamindari, and also to do the multiple thing. But immediately this law was challenged by the another petition in Shankar Prasad case. So this constitutional amendment was again challenged. The owners of the land were not comfortable with this, and this was challenged. Ultimately, when this judgment came, the judgment was ultimately held that the power to amend constitution is including the power to amend fundamental right, and therefore constitutional amendments are not considered to be the in par, and therefore this particular law will not be sustained. So therefore this observation by the Supreme Court was also held that whatever observation has been done by the previous judgment is absolutely correct. So a constitutional amendment will be valid in case it is done. So in this particular case, the Parliament upheld the validity of Schedule 9, which was considered to be the blanket protection to the laws which are made. Then the judgment of IC Golaknath came. There are multiple judgments in between, but three judgments which I am putting in front of you so that you can get to know that how right of property has been completely changed. Now, the discussion started in 1950, reached out in 1967 because in Punjab, the law was created. Now, you read the legislation. I told you earlier that Bihar Land Reform Act. Now, this law is Punjab Security and Land Tenures Act. Now, which is making a particular owner only having a cap that in case you are owner of the land, you are only entitled to keep only 30 acre of land. So remaining all land will be given to tenants, and surplus land will be considered to be the land owned by the state. So it is automatic transfer of the land and property which you have from your ownership to the state ownership. When these particular provisions were came into existence, the family or the affected people challenged ultimately before the court. And this was challenged because the right to property is fundamental right, and how government can take this action by abolishing or by not considering the fundamental right of property. Then the issue came before the court whether amendment is fundamental. This is the constitutional discussion, and finally judgment was that constitutional amendment will be law, and whatever action is taken by government is wrong. The government shall not be entitled to come out with any law which is taking away right to property from the people. And therefore there was a concept of prospective overruling came into picture. So Parliament decided from the date of judgment, there is a 1967, government shall not enact any law which is taking away the fundamental right of people, including fundamental right of property. And this judgment became very powerful, and then people started getting property rights again. Finally, the matter came before the Parliament again in form of the amendment. So there is an interesting discussion which you can always study, that action of Parliament resulted into court judgment. Judgment of the court again is reiterated or is answered by the Parliament. And after this judgment, one more amendment was brought, and then Article 13.4 was added, Article 368 added, and then Parliament said that whatever has been spoken in the judgment, we are reserving our rights to amend the constitution. And these changes were made into the Parliament. Finally, the matter came in form of the Keshavan Bharti versus State of Kerala case, 1973 judgment, in which again the matter was that the Sri Keshavan Bharti was holding Mahant of the Hindu Mutt. When their rights were taken, Kerala government attempted that all the rights over the land will be taken, property will be taken. Again, the matter went to court. And finally, this is considered to be the one of the landmark judgment into history of India, where 13 judges together gave a judgment. And this judgment is considered to be the one of the thing. These are the name of the judges I have written on the screen who were considered to be the judge. And finally, this judgment held that the Parliament does not have any power to violate the fundamental right by virtue of the constitutional amendment. And then there was a provision of the basic structure given. Today also, people remember the basic structure. Whatever we are discussing about right to property has got great connection here. So in 1973, court have held that basic structure should not be violated. An amendment in constitution is valid, but it should not be violating the particular aspect which cannot go beyond the basic structure also. There are different understanding of the basic structure. We are cutting short the discussion and time is not permitting, so we are not going together. But then later on something interesting happened, that in 1978, one of the important aspect happened in form of the amendment into constitution by 44th amendment, because this all amendments about right to property has taken into consideration. And the crux of this all amendments what I am putting in front of you is that government wanted to get the property, they want to manage the property, and therefore in order to facilitate all the actions of government, multiple regulations are enacted in form of the constitutional amendment also. And this all amendments were getting challenged in court of law. Judgments were given by the Supreme Court, and finally a judgment was given by in Keshwanand Bharti case also. When Janta government came in 1978, the first action was taken that by 44th Amendment, the right to property, the 191F got repealed. And now we have the same article in form of the Article 300A. What does it mean? That right to property, which was a fundamental right once upon a time, is not a fundamental right now. It is constitutional right. Now, you will be surprised that why this history we are discussing. Let me tell you, whenever we talk about approaching court for any land law or violation of right, if the any right is given to you in form of the fundamental right, right to go Supreme Court directly under Article 32 is also become our fundamental right. But as you see, in all previous matter, when court are overburdened with multiple actions, because there is always a question before the government that what we should do so that we can have planned development of the state, what we should do so that we can have the abolition of multiple intermediaries, we can have land reform legislation, and therefore multiple legislation were started to be enacted. At the same time, when Parliament was functioning and the Supreme Court was giving negative answer, you cannot do this, the best option was found that now right to property is not a fundamental right but constitutional right. Now, what is the imperative aspect of this? Today, when it has been implemented, approaching High Court under 226 is still available. Whenever you can go to any High Court by virtue of the writ petition when you claim violation of your legal right also. But approaching Supreme Court like earlier is not possible now. This drastic change has done lot of efforts, lot of changes into the property jurisprudence in our country also. But why we say? Because this particular changes have brought multiple functional aspect also. Government also got empowered because now right to property is not a fundamental right, and therefore read Land Acquisition Act in this line, you will find out that right to challenge the land acquisition by virtue of right to property is no more available now. Rather than the petition may be moved to the court where the amount of compensation is less, fair amounts of compensation is not given, rehabilitation resettlement is not granted, and so on. So therefore, whenever land matters are coming into picture, it is always incomplete discussion without trusting this all aspect together. So in order to explain you all these things a little bit, this is not a constitutional discussion, purely constitutional discussion, because we are understanding the entire basic origin of that. But obviously, when time is very less, this particular quick recap can always help you. So finally, the current situation is that we are governed by multiple state legislation. When you talk about the land matter, constitutional aspect is one of the greater, which is covered here. And then every aspect, the legislations, regulations, notifications by the state government about your property rights, about the management of the property rights, about registration of the property, also the zoning certification, also the building and construction laws, which are also part and parcel of the era. When you talk about the height of the building, when you talk about the particular money which is paid by the customers, this all regulations are making the particular journey of the land law very much interesting. So this was the broad overview and introduction of the land matters, and therefore you can always say that this particular thing is very important. Conclusion, you can say right to property has passed through lot of challenges and historical changes. It is one of the subject on which law student does PhD also. Till today, they refer many judgments, they do a lot of research work, and they try to understand. But when you are new, maybe you may be new for land matters and you are reading the land matter first time, holistic approach of all the things together can help you. And I appreciate that I saw the timetable of this particular course where many legislation what I introduce is going to be covered by learned expert person, very renowned speakers are going to approach and they are going to discuss, and ultimately important aspect will be covered. So that was all discussion. I will take some questions. Kalpesh sir, if you permit, there are questions written on the chat box.
Yes, yes. We'll take
Ah,
a maybe
under
uh,
non-agricultural land
yes,
classified.
participant, you can
Yes.
raise your hand also if you want to ask any
Yeah, I
question.
can see some of the questions. Under
Yes, yes.
non-agricultural land, it's classified as one residential, commercial, industrial. But besides this fourth classification, public utility service should be there known. Huh. Public utility service, see, these are the state relating aspect. Every state government is not come out with this kind of state jacket classification. As I told you, it's a state practice available. So sometime they come out the public utility services directly goes under acquisition law. So they without giving them now this residential, commercial, industrial, I told you, because this is zone which is made and you can develop, individual person can develop their land for this. But when public utility service come into picture, it is directly transferred from the people to state, and then state government is always coming into picture. Okay, so therefore I have not made it. Right now, land is converted for multi-purpose in Gujarat. Yes, you are right. Land annexed by the state government request to clarify whether they can annex under list 3 concurrent list or I
There
have
is a one,
clarified this, I think, right?
yeah, there is a one question like how to know the history of landowner as an individual.
Yes, yes. I'll tell you, I will give example of Gujarat. Right now, government is doing excellent work with respect of the e-governance. In Gujarat, there is a e-dhara, right? What government has done, last 50 years records which were physical in nature have been converted and they have created a portal. So what as a citizen you can do, respective state government, you can online get logging. There's a survey number, there's a block number, there is a area which is identified. Every land is given special numbers. I think there is a session which you are going to attend about the record of right. So this will be extended further. In that, you can enter and then you can get completely. There are various forms. I gave example of the land revenue code. In land revenue code, there are various registered. There's a register which is called 7 by 12 abstract, register of 6E, register of 8. Now this register are always maintaining all the history from last 50 years. So originally land was belonging to what? So they are making mutation entry. The moment you note down one mutation entry, that mutation entry record can be found, and accordingly the title advocates, solicitors are having this primary work that they get all the entry they end with. And very interesting thing is these all entries are written in local language. I can also show you entry from Gujarat. They are purely in Gujarat, and that too by handwritten. Old entries are in handwritten. And therefore, whenever you learn land law, be familiar with your local language, because this local language will be primarily dominating, and because the officers who are doing entry are all not mandatory required to be studied in English, right? So this is making the situation very long. So in that way, you can get the record of right. If time permissible, I will share the record of right system of Gujarat. You can have a look to that when I used to practice, and we are also doing that. Yes, any other question? Can open space area be converted into industrial commercial residential? See, interesting question. I don't know who has asked. There is an iPhone which has been mentioned. Now, this is interesting. If open space area is purely for the government has all right, eminent domain. Therefore, I use the word eminent domain. But yes, challenges can always be made under the environmental law. Right now, the National Green Tribunal is there. Okay, so you will find out that NGT's approach where the land is used for any purpose, when it is industrial and environmental things are coming into picture. But yes, the government rights are always prevailing over that, and accordingly, they are entitled to use it. Yes, PPT I'm going to share. Kalpesh sir, it was a long PPT as time is very
Yeah,
less.
no,
I
no
have not
problem.
covered, but yes, those who
Yeah.
are learning land law first, because I'll tell you interesting thing. I don't know how many are law students because whenever you are studying in law colleges, let me tell you that land law is an optional subject as per the Bar Council of India. The BCI has created a list that this many subjects should be taught to students, in which criminal law, civil law, everything is mandatory. But land law is part of the optional subject. I say it's an interesting thing that when advocates practices primary on the land law, it is becoming important to be aware, and therefore that's the reason that many time in colleges the subject will not be offered as a regular subject. But in case you want to understand what I teach, because I teach land law in GNLU from last 12 years, and that entire presentation has been developed so that any basic student can also read it and can get familiar about the land matter. So that will be shared with you for sure.
Sure, definitely. So as you know, participant, I've seen like in Dr.
Yes,
Hardik
there
is
is a
teaching for,
question
yeah.
about groundwater. I told you that groundwater authority, state by authority, has been constituted. Okay, so there is a special regulation on the ground level water, because the slowly gradually the water level is decreasing, and then there is an authority. Now I tell you, in Gujarat, government is giving subsidy for recharging the ground level water. So again, I told you it's a question of the state government. They are coming with the different scheme, and it can be curbed. Any chart or method through which we can understand how partition takes place in various communities. Again, it is very interesting because communities, when you talk, it is traditional systems. Succession Act can help you in case you are talking about Indian Succession Act. You can see that in Succession Act how different partitions are allowed, but ultimately there may be state or practices available. In certain cases, lease period is 33 years, which means land. Yes, lease is always governed by the contract. So whenever lease deed is drafted, there is a contract which is coming into picture, which is giving you right to construct, make a permanent construction also. But with the condition when the lease will be over, this construction will be required to be abolished. So in that way, it is governed. So it's a very broad subject. I congratulate all of you that you have taken interest into such of the wonderful particular aspect, and then
Yes, sure,
it is
sure.
available. Yeah, Succession Act is not having any provision. Yes, Succession Act doesn't have provision of partition, but how the property may be divided, who are the holders, how successor classes. You take about Hindu Succession Act, the names of the classification is available. Later on, those successors can directly approach the court and they can demand that I am entitled for this. And if my successor, or if the person is dying intestate, then what will be the situation? That will be governed together.
Sure. So
Yes.
yeah,
Thank
so
you
I
so
think we
much,
should.
sir. Any other
Yeah, thank you
question?
very much.
Query?
So thank you very much, Dr. Hardik Parikh sir, for your great session, I would say, and setting the stage for the future upcoming session. And let me tell the other participant, it's very difficult to teach land law at national level institution. I have like faced also a lot of issue, and Dr. Hardik also, because students are from all over the India. I was teaching in one of the university where students from 13 countries. So you can imagine, like, they're objecting. So why you are teaching this Gujarat law and then XYZ law? And then let me tell you, I studied Zimbabwe law, and then Africa, Nepal, other countries law I studied, and then I discussed in couple of sessions. So they can also have the feel how land law works. So that was a very difficult task. So idea was to give you in a brief like no outline of the land law, property law, and the real estate, and then I hope you get some chance to enhance your knowledge in upcoming sessions, right? Very deeply, and it's very difficult to cover in, I would say, 75 minutes, but you have done a great job. We'll share the PPT in a while. So thank you very much. Look forward to seeing
Thank
you.
you so much.
Thank you very much.